Today, we will present to you the case of North Sea Continental Shelf, Germany against Denmark and the Netherlands. Fatima Azara will take up the role of the first claimant's counsel, while Nur Aisha Mastura will take up the role of the second claimant's counsel. For the first respondent, it will be Ila Sharifah, and for the second respondent, it will be Ifah Radwa. Sharizal Mizani will be the judge in this Moot presentation.
Assalamualaikum warahmatullahi taala wabarakatuh. My name is Wan Amir Arif bin Manosli. My matrix number is 1202144. Okay, so today I will be explaining on the first part, which is the facts of the case. Netherlands and Denmark rely on the principle of equidistance, which is a treaty law under 1958 Geneva Continental Shelf Convention under Article 6. They both ratified the treaty. Denmark and the Netherlands claimed the principle was to be applied to Germany as well. However, Germany did not agree. They argued that if the delimitation had been determined by the equidistance rule, Germany would have received a small portion of the resource-rich shelf compared to two other states, which is unfair to them. As Germany's North Sea coast is concave, which is curved in bowl-shaped, while the Netherlands and Denmark's coasts are convex, which is rounded. Thus, Germany argued that the length of the coastline should be used to determine the delimitation. Germany wanted the ICJ to apportion the continental shelf to the proportion of the size of the state's adjacent land, which Germany found to be a just and equitable share, and not by the rule of equidistance. Based on the principle of just and equitable share, since Germany did not ratify the treaty 1958 Geneva Continental Shelf Convention, they did not bound by the treaty. Germany argued the principle of equidistance produced an inequitable result for Germany. Due to its concave coastline, the result would be in her losing out on the share of the continental shelf. The principle of equidistance was neither a mandatory rule in delimitation of the continental shelf nor a rule of customary international law that was binding on Germany. However, Denmark and Netherlands insisted the equidistance rule must be applied on the basis of customary international law.
Moving on to the first claimant.
Good morning, Mr. President and Judge of the Court. May it please this Honorable Court. My name is Fatima Azara, appearing as the Senior Counsel on behalf of the appellant, the Federal Republic of Germany. Appearing together with me today is my co-counsel, Ms. Aisha Mastura. On behalf of the respondents, we have the lead counsel, Ms. Nur Ila Sharifah, and she will be assisted by her co-counsel, Ms. Ifah Radwa. Mr. President and Judge of the Court, we wish to put forward two arguments. I will be dealing with the first issue, and the remaining submission will be dealt with by my co-counsel. Before we proceed, allow me to assist this Honorable Court with the facts of the case. This case concerns the delimitation of the continental shelf of the North Sea between Denmark and the Federal Republic of Germany and between the Netherlands and the Federal Republic of Germany. The parties asked the court to state the principles and rules of international law applicable and determine where the maritime borders of their countries were. Germany relies on the just and equitable principle, whereas the Netherlands and Denmark rely on the equidistant principles in the 1958 Geneva Convention on the Continental Shelf. The Netherlands and Denmark claim that the treaty supports this method, and it has been a rule of customary international law. However, Germany, which had not ratified the Geneva Convention, claimed that the rule of equidistance is unfair. The state argues for an apportionment of the shelf that is proportional to the size of each state's adjacent land. Having finished with the facts of the case, I shall now proceed with my submission. There are two issues to be submitted before this Honorable Court. I will be submitting on the first issue, and my co-counsel will be submitting on the second issue. I will divide the first issue into two parts, which are first, the delimitation of the continental shelf between the parties in the North Sea is governed by the principle that each coastal state is entitled to a just and equitable share. Second, the Federal Republic of Germany is not bound by the principle of equidistance in the 1958 Geneva Continental Shelf Convention. For the first issue, we submit that the delimitation of the continental shelf between the parties in the North Sea is governed by the principle that each coastal state is entitled to a just and equitable share. I would like to draw this Honorable Court's attention to the geographical situation in the North Sea. Germany's North Sea coast is concave, while the Netherlands and Denmark coasts are convex. Hence, if the delimitation had been determined by the equidistance rule, the German portion of the North Sea would reduce to a small fraction of the total area, which does not reflect the extent of its contact with the North Sea. Secondly, the German portion will extend only halfway to the center of the North Sea, where the British, Norwegian, Danish, and Dutch portion meets. And thirdly, the square area of the German portion would be roughly 40% of the area of Denmark or the Netherlands. Hence, due to its concave coastline, Germany would receive a smaller portion of the resource-rich shelf than the other two states if the equidistant principle was applied. In light of the fact that the principle of equidistance produced an unjust result for Germany, we would like to submit that the principle that each coastal state is entitled to the principle of just and equitable share. As for the second ground, the Federal Republic of Germany is not bound by the principle of equidistance in the 1958 Geneva Continental Shelf Convention. Denmark and the Netherlands signed the Treaty on the Continental Shelf, to which both of the countries were parties, but Germany was not. Hence, the treaty could not be directly applied against Germany as Germany signed the treaty but did not ratify it. The principle of equidistance was neither a mandatory rule in the delimitation of the continental shelf or a rule of customary international law that is binding on Germany. Therefore, Germany is under no obligation to accept the equidistant method as the method does not lead to an equitable apportionment of the continental shelf between the parties. Hence, we would like to submit that the geographical situation in that part of the North Sea required another boundary line, a boundary line that will be more equitable to both parties to the dispute. Having finished with the argument for the first issue, that shall conclude my submission. Thank you, Mr. President and Judge of the Court, for your time and indulgence.
May it please the court, my name is Nur Asha Masra, and I am appearing as junior counsel for the appellant, the Federal Republic of Germany. On behalf of our client, shall I address the second argument that we are concerned about? Mr. President and Judge of the Court, in order to resolve this issue, it is necessary to refer to some of the relevant principles that govern the subject at hand, one of which is that we, the Federal Republic of Germany, are not bound by the principle of equidistance in 1958 Geneva Continental Shelf Convention, as it's not a rule of customary international law. As I mentioned here, the equidistance method is the method of determining the boundaries of the continental shelf in such a way that every point of the boundary is equidistant from the nearest points of the baseline from which the breadth of the territorial sea of each state is measured, according to the second sentence of paragraph 2 of the Article 6 of the Continental Shelf Convention, which prescribes that in the absence of the agreement and unless another boundary is justified by special circumstances, the boundary shall be determined by applications of the principle of equidistance. This has not been codified in customary international law. Mr. President and Judge of the Court, it is important to note that Article 6 of Convention say that the equidistance line only applies if the country involved cannot agree on how to divide the continental shelf, and if there are not any special circumstances that will make a different boundary line more appropriate. This formula in Article 6 put a lot of limits on how the equidistance method can be used. It also confirmed that what said above, that the equidistance method can only be used to the extent and for as long as it needed to ensure a fair and just divisions of the continental shelf areas between the states involved. Furthermore, we can interpret that Article 6 of paragraph 2 of the Geneva Convention could be seen as creating a presumption in favor of the equidistance method. The agreement drafters believe that the equidistance lines will usually produce a fair decisions. They advise using the equidistance method unless specific circumstances need a borderline to be defined. Even though Article 6, paragraph 2 of the Convention may be regarded as providing a presumption in favor of equidistance technique, it only can be applied against a state who have joined the Convention without reserving Article 6. But it cannot be used against a state that has not agreed to Article 6, and presumptions like that cannot be seen as having the force of customary law, as all states must follow. Even if the presumption could be used to support the equidistance line between the parties, this does not give a valid title to equidistance boundary as long as the other party dispute the issue, the use of this method, and the dispute has not been settled by the agreements or arbitration. Mr. President and Judge of the Court, here I would like to emphasize that the equidistance method cannot be used for the delimitations of the continental shelf unless it has been determined through agreements or arbitrations or other means that it will result in a just and equitable distributions of the continental shelf among the states involved. The Kingdom of Denmark and the Kingdom of Netherlands cannot rely on the equal distance method when deciding how to divide the continental shelf between the parties in the North Sea, because it will not result in a fair division. Thus, before I conclude, I would like to reiterate that first, the delimitations of the continental shelf between the parties in the North Sea is guided by the principle that each coastal state is entitled to a just and equitable share, and second, the Federal Republic of Germany is not bound by Geneva Convention principle of equidistance, since it's not a rule of customary international law. Having finished with the argument, thank you for your time and indulgence.
Now, moving on to the first respondent.
Mr. President and Judge of the Court, may it please this Honorable Court, my name is Norila Sharifah, appearing as the Senior Counsel on behalf of the respondent, the governments of the Kingdom of Denmark and the Kingdom of the Netherlands. There are two issues to be submitted before this Honorable Court, as I will be submitting the first issue. Appearing together with me, my junior counsel will further address on the second issue. On behalf of the respondents, I will address for the first issue raised, whether the principle of the equidistance by the virtue of Article 6 of Geneva Convention 1958 is bound by the Federal Republic of Germany. Mr. President and Judge of the Court, it has been asserted that only Denmark and the Netherlands had both signed and ratified the convention and were parties to it. Meanwhile, the Federal Republic of Germany had only signed but never ratified it, thus consequently assuming that it was not a party to it. Nevertheless, it is contended that the convention or the regime of the convention, where in particular of Article 6, has become binding on the Federal Republic in another way, namely by the conduct, by the public statements and proclamations, whether in its public declarations concerning its continental shelf rights it appeared to rely on, or at least cited, certain provisions of the Geneva Convention. Furthermore, the Republic has unilaterally assumed the obligations of the Convention or has manifested its acceptance of the conventional regime. For instance, at the Geneva Conference, the Federal Republic did not take formal objection to Article 6 and eventually signed the Convention without entering any reservation in respect of that provision, that it at one time announced its intention to ratify the Convention or has recognized it as being generally applicable to the delimitation of continental shelf areas. Additionally, the Federal Republic either had held itself out as so assuming, accepting or recognizing in such a manner as to cause other states, and in particular Denmark and the Netherlands, came to rely on the stance adopted. Moreover, the claim that Article 6 of the Convention has had influence and resulted in the effect described clearly involves treating the article as a norm-creating provision that has served as the basis for or produced a rule that, while initially only conventional or contractual, has since entered the general body of international law and is now recognized as such by the opinion jury, so as to have become binding, even for countries which have never and do not become the parties of the Convention. Therefore, it could be seen that under Article 6 of Geneva Convention 1958, the use of the equidistance method is rendered obligatory for the present delimitations by virtue of the delimitations provision of the instrument, according to the conditions laid down in it. As alleged that Article 6 of Geneva Convention 1958, paragraph 2 was not only to be applicable as a conventional rule, but also to represent the accepted rule of general international law on the subject of continental shelf delimitation, as it exists independently of the convention, which has been detailed that the boundary of the continental shelf must be determined by agreement between the territories of the two adjacent states when the same continental shelf is next to their borders. In the absence of agreement, and unless another boundary line is justified by special circumstances, the boundary will be established using the principle of equidistance from the closest points of the baselines from which the breadth of the territorial sea of each state is measured. Hence, Article 6 of the Geneva Convention, as the Court knows, has two principal paragraphs where it is necessary to draw the Court's attention to the provisions of both paragraphs 1 and 2 of Article 6. First off, which applies to states whose coasts are opposite each other, and the second off, which applies to states whose territories are adjacent to each other. Thus, apart from the close similarity of the language, the substantive rules stated respectively for opposite and adjacent states in the two paragraphs are precisely the same. This is because Article 6 does not distinguish in any way between the treatment of the two cases. Besides, there is not slight trace in Article 6 that the application of the equidistance principle may be equitable and appropriate in the case of median lines between opposite states and also of lateral lines between adjacent states near the coast. It is altogether unsuitable for the delimitation of larger submarine areas out in the open sea. Hence, we would like to submit that the equidistant principle was deliberately adopted by the Commission and the Conference as the general rule, which includes the Federal Republic of Germany. Having finished with the first issue, on behalf of the respondent, that shall conclude my submission. Thank you, Mr. President and Judge of the Court, for your time and indulgence.
Assalamualaikum. May it please the court. My name is Ifaradwa and I am appearing as junior counsel for the defendants, the Kingdom of the Netherlands and the Government of Denmark. On behalf of our client, I would like to address the second issue raised by our client on whether the Federal Republic of Germany is bound to follow the equidistant principle under customary international law. Mr. President and Judge of the Court, regardless of whether the equidistant principle may be in relation to the Geneva Convention or not, in any event, the parties are bound to accept this delimitation principle as it is regarded as involving a rule that is part of the corpus of customary international law, which is similar to other rules of customary international law as it binding on the Federal Republic automatically and independently. This allegation is made based on two aspects, which are positive law and fundamentalist aspect. As a matter of positive law, it is based on the work done by international legal bodies, state practice, and the influence attributed to the Geneva Convention itself. These various factors have cumulatively evidenced requisite for the formation of new rules of customary international law. Next, the fundamentalist aspect, the view put forward derives from what might be called the natural law of the continental shelf, in the sense that the equidistant principle is seen as a necessary expression in the field of delimitation of the accepted doctrine of the exclusive appertenance of the continental shelf to the nearby coastal state, and therefore as having a priori character of legal inevitability. Mr. President and Judge of the Court, I would like to stress that the delimitation must be done in a way that gives each of the involved states access to the territories closest to their own coast, and this could only be done by applying the principle of equidistance. In addition, the doctrine of just and equitable share raised by the claimant is not the right method to be applied in delimiting the continental shelf, as the coastal states' right exists ipso facto and ab initio, without there being any question of having to make a good claim to the areas concerned or of any apportionment of the continental shelf between different states. In fact, the delimitation itself must be carried out fairly, but it cannot have as its goal the distribution of an equitable part or even a share in general, because the underlying idea does not permit the existence of anything undivided to be distributed. Before I conclude, I would like to reiterate that, first, the delimitation of the continental shelf between the parties shall be guided by the principle of equidistance by virtue to Article 6 of the Geneva Convention, and second, this principle had fall under the customary international law, which lies within the positive law and the fundamentalist aspects. Having finished with the argument, thank you for your time and indulgence.
Order in the court.
Most counsels have brought upon us two questions of law, namely is the 1958 Geneva Convention, and in particular Article 6 binding on Germany, and is the appellant bound by the provisions of Article 6 of the Geneva Convention insofar as they reflect customary international law. To answer the first question, is the 1958 Geneva Convention, and in particular Article 6 binding on Germany. Article 6 of the Geneva Convention stated that unless the parties had already agreed on a method for delimitation or unless special circumstances exist, the equidistance method would apply. Germany had signed but not ratified the Geneva Convention, while Netherlands and Denmark were parties to the convention. The latter two states argued that while Germany is not a party to the convention by not having ratified it, she was still bound by Article 6 of the convention. The first argument is hereby rejected. We observe that only a very definite, very consistent course of conduct on the part of a state would allow us to presume that the state had somehow become bound by the treaty when the state was at all times fully able and entitled to accept the treaty commitments in a formal manner. Germany, the appellant, had not unilaterally assumed obligations under the convention, and we took notice of the fact that even if Germany ratified the treaty, she had the option of entering into a reservation on Article 6, following which that particular article would no longer be applicable to the appellant, Germany. In conclusion, we found that Germany had not acted in any manner so as to incur obligations contained in Article 6 of the Geneva Convention. Hence, the equidistance special circumstances rule was not binding on Germany by way of treaty law. And we proceed with the second question of law. Is Germany bound by the provisions of Article 6 of the Geneva Convention insofar as they reflect customary international law? Netherlands and Denmark, the respondents argued that Article 6 also reflected the accepted rule of general international law on the subject of continental shelf delimitation, and that it existed independently of the convention. Therefore, the respondent argued Germany is bound by the subject matter of Article 6 by way of customary international law. Hence, to decide if the equidistance principle bound Germany by way of customary international law, we had examined the status of the principle contained in Article 6 as it stood when the convention was being drawn up and its status after the convention came into force. We found that the principle of equidistance as contained in Article 6 did not form part of existing or emerging customary international law at the time of drafting the convention. This is based on the hesitation expressed by the drafters of the convention, the International Law Commission, on the inclusion of Article 6 into the convention, and the fact that reservations to Article 6 were permissible under the convention. We also had further examined whether the rule contained in Article 6 had become customary international law after the convention entered into force, either due to convention itself or because of subsequent state practice, and we found that Article 6 of the convention had not attained a customary law status. It must be observed that for a customary rule to emerge, it needed a very widespread and representative participation in the convention, including states whose interests were specially affected, virtually uniform practice, and in this instant case, we found that the passage of a considerable period of time was unnecessary for the formation of customary law. In conclusion, the equidistance principle was not binding on the appellant Germany by way of treaty or customary international law, and in the case of the latter, the principle had not attained customary international law status at the time of the entry into force of the Geneva Convention or thereafter. As such, we found the use of the equidistance method is no longer obligatory for the delimitation of the areas concerned in the present proceedings. Case hereby dismissed. Thank you.
For the last part, which is the summary of this case, the first question is, why is Article 6 under equidistance rule not binding on Germany based on treaty obligation 1958 Geneva Continental Shelf Convention? The answer is Germany signed but do not ratify the convention. No ratification is not the party to the treaty. For the second question, why is Article 6, which involved around equidistance rule, not binding on Germany based on customary international law obligation? The answer is, in this situation, the court need to examine customary law status of principle based on the first part, which is time of the drafting of the convention. For the first aspect, the principle of equidistance did not form a part of existing or emerging customary international law at the time of drafting the convention. The reason was because of the hesitation of the drafters of the convention. Reservations to Article 6 was permissible under the convention. The second part is status after the convention came into force. For the second aspect, the principle had not attained a customary law status. That's all from us. Thank you very much.